All righty, welcome everybody. It looks like we're all set. I see a few people have joined in over the phone, and I am just going to mute everyone who's on the phone just so we can hear clearly. There we go. Welcome everybody to our Rush Generations lecture on end of life care and advanced directives. This is such an important topic, and so we're so grateful to see people signing up already. We're going to go ahead and get started. Thank you again for finding your way to this lecture, whether you've joined in over the phone or if you've joined in online. We're going to start just very briefly with just some idea of what this day is going to look like. All right, so we're going to start off with a lecture by Aoife, who is a chaplain, and she will be discussing values-based healthcare decision-making. After that part, we'll be talking about advanced directives under the Illinois law, so a more legal perspective. And then towards the end of the lecture, we will have time for question and answer. And so how it's going to work is if you've joined in over on the computer, if you're joining on YouTube, there's a chat box. So if you've joined in on your desktop, so on your computer, you're going to see a screen that looks just like this. So the chat box is to the right side of the screen, and you can type in any of your questions or comments throughout the lecture. If you've joined on a phone or if you've joined in on a tablet, that chat box will be under the video screen. So wherever you see the live chat button, you can go ahead and click that, type in any questions or comments that you have at any point throughout the lecture. Then for the last 10, 15 minutes or so of the lecture, I'll be able to share those questions with our speakers so that they can answer them. All right, so without further ado, I'm gonna go ahead and introduce our two great speakers for today. So first, starting off with Aoife. Aoife is from Ireland, where she was a social worker in family services for over 15 years. She came to Chicago to study spirituality and pastoral care. She has a Master's of Divinity from Loyola University Chicago and a Doctorate of Ministry from Catholic Theological Union in Hyde Park. She completed her chaplain training at Rush University Medical Center and was a staff chaplain for 5 years before going to Rush Oak Park Hospital as the Director of Spiritual Care and Mission 15 years ago. In this role, she also co-chairs the Ethics Committee for Rush Oak Park Hospital. In 2016, she became a Coleman Palliative Medicine Fellow, and as a palliative care chaplain, she supports daily patients and families facing life-limiting situations. So we're very grateful to have Aoife here today with us. After Aoife, David Lee will be discussing more of advanced directives and the legal side. David is an assistant general counsel at Rush University System for Health. His area of specialty is in patients' rights, in particular informed consent, advanced directives, alternate decision-making, mental health, and probate laws. As an attorney since 2013, he has worked as a prosecutor in the Cook County State's Attorney Office, including the Special Prosecution Unit, as well as the Department of Persons with Disabilities and the Mental Health Court Division. Since joining Rush in 2018, he currently holds a faculty position as an assistant professor of Rush Medical College, lecturing on medical legal topics such as involuntary admission, power of attorney for healthcare, medical documentation, and privacy laws. He works closely with the clinical risk management team in the Office of Risk and Claims Division of Rush Legal. So without further ado, we're going to start off with the first portion of our lecture with Aoife.
Thank you, Jasmine. So I think now I press this button that says share my screen.
Yes, correct.
We open that up and
you're all set.
And we're all set to go. So I hope everybody can hear me clearly, and I will ramble just for a minute. So I'm glad that Jasmine mentioned that I am from Ireland. That gives you time to adjust to my voice. and more so to stop wondering where I'm from. So, so it's interesting that that David and I are from two different parts of the world, and we are not related, even though we both share the same last name. So I think the first thing I'm supposed to do, if it works for me, is say that I've nothing to disclose. I'm not even sure what I would have to disclose if I had something to disclose, but I don't. So I hope that by the time we finish here this afternoon, that not only will you have a better understanding of the what and the why about advanced directives, but also to be able to distinguish between the different types of advanced care planning and advanced directives that are out there. So for my part, I come at this from a values-based healthcare decision-making stance. So like many of you listening, I'm guessing maybe you're not clinical people, you're not medical people, you're not necessarily folks who have spent a lot of time in an intensive care unit and who know all the medical language that we hear very frequently. For example, I nearly said ICU, and I forget that people don't readily understand what ICU stands for. It is intensive care unit. So like Jasmine said, a few years ago, after maybe 15 years of working as a chaplain but at Rush, what we call Big Rush, and now Little Rush at Oak Park, I have spent many hours supporting people trying to make hard decisions. And then a few years ago, when I became a Coleman Palliative Medicine Fellow, I had the opportunity to work with one of our primary care physicians in their office. And this is where I developed the idea of values-based healthcare decision-making. So there are three aspects to this as I see it. The first, to decision-making in this arena, the first is values. Know what's important to you. I often, when I'm having conversations with patients, I try to get a sense, or their families, I try to get a sense of this whole person, their life. What was their life like? What has happened in recent years that somebody is now in this situation? And usually the situation I'm thinking of is in critical care within the hospital. But before that, even just to look at, what has happened for you in life that helps shapes your values. Your values will help shape your decisions, what way you would go. Sometimes I use the term where you would draw the line. Once kind of you have thought about values, what's hand in hand with that's important is to have conversations with your loved ones. And with your physicians. Sometimes people will say to me, my daughter knows what I want. Well, your doctor needs to know also what you want and what you don't want in terms of medical stuff. So having conversations with your family, and then finally, how to communicate those conversations. That last piece I'm going to touch on, but obviously that's going to be where David will go into far greater detail and the legal ramifications of that. The signpost, sometimes I give these talks not only to people who are, patients or people who are not in the medical field, but I also give it to medical students, to nurses, to doctors, to social workers. And when I pull up this little image here that's on this slide of the signpost with all the arrows pointing different directions and the question mark, I pose the question to my audience, is this you? Is this your doctor? Is this your family? Who's puzzled? So hopefully if we get everything in order, nobody will be puzzled, would be my aim at the end of all of this. All right. So I again like to use kind of popular, everyday, accessible um, materials that people might be familiar with. Many may have read the book Being Mortal by a physician from the East Coast who talks about the his father's life and the demise of his father, and the questions that came up about that, but the whole sense of being aware of our mortality. Um, Knocking on Heaven's Door by Kathy Butler is a similar vein. It's people talking about their own personal experience of the death, the illness, the sickness, the and the death of a parent or parents. In Kathy's case, those two books are very readable, and there are only a couple that I have found very helpful to help think through some of these things. The other book that I put up there is called The Other Talk. It's an AARP publication. I came out a number of years ago, and if there is anybody who is like me on this conference call, we're baby boomers. I'm kind of in the middle stage of baby boomer generation. Somebody might be the older age baby boomers. What I like particularly about The Other Talk is we remember the phrase, the talk that you had to give to your children. Usually it was about the birds and bees and about how to take care of yourself and about your sexual life, about the children's sexual life, not your own. And but this is a kind of a play on that. It's The Other Talk, and it puts an onus on us as baby boomers or as the older generation to help our adult children to know not only what we would want at the end of life, but also how to cope at the end of life. But it puts that onus on the older generation to talk to the younger generation about this sort of time, so that the younger generation are not left floundering around the place and not knowing what to do. Anyway, it's a great and another very readable publication. Two other pieces that people might be familiar with is you may have heard of this document called the Five Wishes. David will probably go maybe address that a little bit more, but I just use it. I put it out there because I want to acknowledge that it exists. It's a very helpful document to go through with somebody because it goes into all sorts of details about what you would want and where you would want and how you would want things done when your health fails you, and when you are facing your demise, and kind of what you'd want for your funeral and things like that. So it has a very broad spectrum of questions for you to reflect on, and then you fill out the document, and then you have that so that your loved ones have an idea of what to do after you've gone. The Conversation Project is also a similar sort of thing. That's something you would have to Google and pull up on the internet. But it's a project. There's two steps to it that was developed to try and help people again know how to start this conversation, either as the older person doing it with your children, or even for the children with their parents, or and I use those terms, but I mean whatever significant people that will be in your life supporting you. But like I said, advanced care planning is about values-based healthcare decision making, and how I hope to live my life as fully as possible up to and including the end of it. So how I hope to live my life as fully as possible up to and including the end of it. I am, Jasmine, I'm sure you're going to be able to cut in and say, Aoife, you've got 5 minutes, because I could talk for too long. So anyway, I have many examples, but there's a couple that comes to mind. I had a patient one time, a woman who was, I want to say maybe she was in her early 80s at this stage, but had been living in assisted living and doing well and engaged in things that she was able to engage in and all the rest, while she continued to have her healthcare issues. And I can't remember exactly what issue she had, but possibly a diabetes or diabetic. She was possibly diabetic. And maybe with that, she also had a circulation problem. And I say that because she was now facing, and maybe there was an infection. There might be wound not healing, an infection, that type of unfortunate um, process that occurs to us. Um, and she had decided to draw the line at not having any limb amputated. And she was very with it. She hadn't got any dementia going on. She wasn't, manic depressive or anything like that. She was very clear about how she had lived her life and how she wanted to go on to meet her maker, to go on to the next life, to go move forward into whatever comes next, whatever language you like to put on that. She was very clear she was not going to have any amputation. And if that meant that she was going to die, that was fine with her. She wanted to go to be back in her own rooms in the assisted living situation, to be able to see her family, to be with her friends, and she and of course I get called in on this because the doctors are all, oh my God, she's perfectly able to live longer if she lets us cut her leg off. But she didn't want that. She didn't want to live without one of her legs. And so I was called in to talk with her, and this is what I got: a very sensible, faith-filled woman who was appreciative of life, and she was very clear that this was the right thing for her to do. This is where she wanted to be, and not not spend another year getting parts of her body, amputated and then die. She wanted to go back to be in her own rooms and all that. And so there was nothing. That was it. We needed to follow her wishes. I said to her, the best way then that we as a healthcare team can support you in doing that is by you being discharged with hospice support back at home in your own place, which is what she did. And she got great support. They tended to her physical needs and made sure her symptoms, that she had no pain, that she was able to receive visitors, see people, do what she needed to do. And after I think it was probably 3 or 4 weeks, she slipped. She gradually became unconscious and then just slipped away in her sleep at home, and everybody was supported and everybody was at peace. So that's kind of what I always think of. She's the woman I think of when I have this idea of living my life as fully as possible, up to and including the end of it. So, having said that, by now you're very aware that I can very easily talk about dying. It's part of being Irish. We are brought up to know that we're all going to die, and we're very. I was brought up in a situation whereby people died, and I would have been there. I might not have been there. It's a part of life. It's a fact of life. I've discovered that it's not quite the same fact of life over here in the States, but anyway. So, what's the unspoken reality behind advanced care planning? That's what I want to help you think through a little bit today. And what it says to me is that a moment will come when I will not be. I will not be what? Just as I was starting my project for the coma palliative medicine, I suffered 2 tears in my right retina, and the retina detached, and I lost the sight in my right eye. And subsequently, I've had many surgeries on it. And my sight is definitely not the same as it was in 2015 as it became in the beginning of 2016. And that has had more impact on me than anybody would have told me beforehand, I can tell you. For anybody who has had eye trouble and retina detachment, I'm sure you understand this. There is degrees to retina detachment. I seem to have had a very complex complex case with it all, and my eye doctors are always sort of amazed that I can see anything at all, really, out of that right eye, but I can. So, but it definitely causes me to realize, something else will go as I get older. Something else is going to go. I'm not going to be quite as sharp, or I'm not as mobile as I used to be. Um, I will become more incapacitated. The time is going to come, when I'm going to just feel too tired to live. And certainly, even at this point, I reckon that there is more time behind me than there is ahead of me. I'm not quite, thankfully, in a position like my parents would have been, where they had more friends in heaven than they had left here behind. But there's definitely more time. I've lived more life than I'm going to live, shall we put it that way. So sitting with this reality, I think, I hope anyway, helps us to kind of realize what's important. For many people, that independence is so important. People, so I work at Oak Park, Rush Oak Park Hospital, which is, Oak Park is an old community with big houses, of people who raise their children in these big houses, and the kids are all gone, and they want to be carried out feet first from their house. They're not going to give up their family home. And even though I many a time will say to somebody, I hope you decide when you're going to leave the house, downsize, move somewhere where you can be helped and supported, and not have it forced upon you because you've fallen and fractured a hip and now you can't go home again. So that fierce independence is very important to some people. Other families, other communities, other cultures, and we have such a mix of cultures, it's much more communal based. And so the sense of, three generations living together is much more usual for some of our patients. And there isn't that same level of independence, of needing to be on my own in my own place and come whatever comes. Probably, so that's a reality. That's a self-knowledge. We want to look at what do we know about ourselves. At the moment, maybe most of us are making our own decisions. Again, are we making decisions just for ourselves? Are we now making decisions for our spouses, and we don't really realize that's what we're doing? In talking with a woman one time about doing a power of attorney for healthcare with her, she said, "Oh no, I'm fine," and I said, "Yes." I said, "But the default person is in her case, is your husband." And I said, "So if something happened to you, your husband will be the one making decisions, if you don't name somebody else, like one of the children." And she said, "Oh, hold on a second. He's got some early dementia going on." And that helped her to realize, maybe my husband is not really able to do this. So looking at the decision-making process, we make our own decisions now, but if we can't, and in the blink of an eye, and I pardon the pun because I did talk about my sight, but in the blink of an eye, that can change. We can have a stroke. We can have an aneurysm. We can have something major happen to us that we can't make decisions for ourselves. As Jasmine mentioned in the little bio about me, I co-chair the ethics committee at Oak Park, and have done with with different physicians over the years. But one of those decision-making things that comes up is not only naming that person. I'm not losing my train of thought here for a moment. But we make our own decisions. We appoint somebody else to make decisions for us. And that helps us to stay in control in some shape or form of decisions in the future. So there is mechanisms, and maybe David will go into those, if we don't automatically, if we don't have somebody to make a decision that has been appointed. Um, but I won't go into that too much now. But we know that is a value of making our own decisions. Our safety, that's a very important piece. An older friend of mine moved into a one of these living situation communities whereby it's continuity of care. So she knows she's going to be in this facility, and she's currently in her own rooms now in sort of independent living. She knows she could go into assisted living, and there's a hospital floor on it and all that. But frequently in recent times, she has said to me, she feels so safe because she's not alone as much as she would have been if she remained in her house. So safety can be an important value that allows one then to make a life change from the living circumstances you're in now to something else. A little bit more on that, a little sort of twist on all of this too, is helping my family, my children, my loved ones, my friends, is getting my affairs in order helps them. You're still being a parent, even if you're on your deathbed, if somehow you have left instructions to your kids as to what to do. And if you do include hospice in that, one of the benefits of engaging in hospice at the end of life, and that's usually, that means the expectation is somebody's going to die from their condition within 6 months. Doesn't mean you have to die within 6 months because it's renewed. It just has to be reviewed, but you have a qualifying diagnosis where the healthcare team would not be surprised if you were to pass away within a 6-month period. What happens after you, not only during that time, but also after you have passed away, is your loved ones get continued support. I was talking to a colleague that I bumped into this morning whose mother had died a few months back, and I just wanted to check with her. It's coming up to Thanksgiving. She's now on her own. She and her mother lived together for decades and decades. And so we chatted a little bit about that. But she said to me one of the best things was that the mother went into hospice care because they will call her every so often to check in on how she is doing. How the daughter whose mother has died, how are you doing, daughter, with this, as you're coping with the bereavement of your mother. That support goes on for 13 months. So a month after the anniversary of the person's death. Um, and that can be a tremendous gift to give to your children or to give to your loved ones in terms of support after you've died. Faith, of course, is an important value. For some people, there's nothing after this life, and for others, there is many things to look forward to. Like I said, there's more people who have gone before us, waiting for us, perhaps, than there is left around us. When I talk with 90-year-olds who said they're all gone, all my friends are gone, the whole family are gone, I'm the last of the generation. But there is a sense of faith that there is something ahead of us as well. And how does that influence the decisions I make now, today? So when we look at that, all of this sort of reality and these values that I want people to look at are they in conflict or are they congruent? So probably the best one of the best things that I could say, examples of that, is people will often say, either about themselves or about their loved one, I don't want to suffer. I don't want to suffer. Well, I want everything done and I don't want to suffer. And there's a conflict there, because everything being done, like the example of the woman I told you earlier, everything being done would include maybe surgeries, maybe being out of your house, maybe being in a facility on a ventilator machine, maybe having not able to be conscious or not able to talk to somebody. So the healthcare world can keep people alive on machines, not forever, there's a limit to what they can do, of course. But they can certainly draw out the end stages for a longish period. And that may not be something that you would actually want, nor would you want it for your loved ones. Again, I know as I talk to folks now on the phone, because they can't be in the intensive care unit with their mother or father or loved one, um, and but their loved one is unconscious on a ventilator, not knowing what's going on, and the people who are suffering are the family members. And if if as a mother thought that their children was suffering because I'm on these machines and I'm not going anywhere, and they're just, everybody is stuck, um then maybe I might have wished I had said, don't put me on the machines. So so you want to have that sort of, I don't want to suffer, I want everything. There can be some incongruence, that can be in conflict, and some of those values. So um, living alone in my home and being safe may not go together. That sort of thing. Anyway, I'll get on to the second. That the values, to me, I'm going to do most of my talking about values, because that to me is the driver of advanced directives, advanced care planning. If you don't know what your values are, then you're going to be just dealing with practical stuff, and it'll be hard to have some weight behind it. The values are very important. Next, then, of course, as I said, is a conversation. Talk and talk frequently about your values, about what you would want, what you wouldn't want. What do your family want? Um, you want to live on your own in your own place, but your family is worried. I go back to my friend who moved into the continuous care situation. It was a great relief to her only daughter, who lives in Connecticut, and that is, for the sake of her daughter's peace of mind, the mother moved in somewhere. So, think of your family's values too, and how you can continue to help and care for your family. And be aware that these values change. We get older, our health changes, everything changes, life changes. And that's why I put in the idea of the annually review your values and your decisions. I had a social work colleague one time who said that the family Thanksgiving dinner, um, every year she brought a pack of advanced directives to the dinner. Everybody else brought food. She brought advanced directives and said, okay, folks, we're taking 10 minutes to look at these. Has everybody got theirs? Is everything in order? Are we changing anything? And she kept it all to the fore every year with her family. So there was no doubt, lots of conversations was happening in that family. So this really is by way of a very unlegal introduction to types of advanced directives. So we, in the healthcare world, we tend to use this term advanced directives, and we're thinking mostly of the power of attorney for healthcare, perhaps the living will as well. But I've discovered very recently in a case that in a situation that we had with a man in his 50s who had lots of medical issues, and really, he was on very thin ice. And the only one of all of these things that I've written up here, if you can see the screen, I've talked about a will. We often do it if we have property or money. You might, people will have power of attorney for property, or they'll do a trust fund and make a will so that the money end of things are taken care of, but they don't necessarily do the healthcare stuff. But this gentleman, the only thing he had done was he had actually gone in and registered it as an organ donor. And we didn't have a clear power of attorney person. It was like he had a daughter in her early 20s who was absolutely freaked out by everything that was happening. And thankfully there was, his ex-wife actually did ended up being the person who was making decisions with other family members. But he had actually made a decision to be an organ donor, and I had not until a few weeks ago realized that's an advance directive, because I've already made a point. I've already said I want to donate my organs should I die, and then David can talk to this in Illinois some years ago. Um, Once somebody had actually registered on the registry for organ donation, not just simply signing the back of your driver's license, you actually have to register. That cannot be overridden by the family saying, no, we don't want to do that. It's already a decision the deceased person has made, so that has to be carried out. So that's a little bit of an unusual advance directive, but there it is. It is one. Prepaid funerals are, in a sense, advance directives. We're directing our family as to what to do because we've got some things prepared. Lastly, on this slide, I want to say the power of attorney for healthcare is probably the one that in the healthcare, as a healthcare professional in the hospital, with my doctors and nurses and all the other team members, knowing who the decision maker when the patient can't make decisions is very important for the whole sense of continuity of care, of knowing what to do. So naming and documenting who that person is a very important piece. Obviously, talking to that person so the person knows what your wishes will be goes hand in hand with that. Not infrequently will people also do a living will. And the living will is not what some people think it is, I've come across. Because the living will, for many folks that I've come who are in an assisted living type situation or retired community or something, and they get a bundle, they get a will and a power of attorney for property and a trust fund and healthcare, and they get this living will tied in as well. And they think that the living will means that they are not going to receive extraordinary aggressive treatment when they passed away. That's not the case. The living will, is an indication that if in the mind of my physicians that I am in the dying process, I do not want extraordinary interventions. But it is not the same as the red document, which is the physician's order, or the practitioner's order for life-sustaining treatment, commonly referred to as a DNR. There was a time when we tried to get away from that DNR, do not resuscitate, and have it called allow natural death, but that never caught on in popular vocabulary. But the living will is not a doctor's order which is a doctor's order to the healthcare team, including the emergency medicine team, the EMS service that will come to a house or a living situation after 911 has been called, and they are obliged to, if they don't get a pulse, if they don't feel a pulse, they're obliged to try and resuscitate somebody, unless they see that this order has been in place. So that order is an important one, but it's a doctor's order, so you have to go to your doctor to get that signed, that red document signed. But just by way of being clear, a living will is not the same as a DNR document. David probably will go into some of that maybe a little bit more, or I can answer questions on it. And I think my last slide is a little recap to encourage you all to identify your values, to think through it all, to think about where you would draw the line in relation to how much healthcare you would allow yourself to go through. Some people will say, oh my goodness, I wouldn't put my 93-year-old father through surgery, and yet they would still have them be resuscitated if they were to die peacefully in their sleep. Not realizing that trying to resuscitate somebody is far more aggressive than going through a surgery, perhaps. So anyway, identify your values, talk to your family, talk to your doctors. There's no point in saying somebody knows and your doctor doesn't know, because the doctor's the one who's going to be doing it to you. Document your decisions. Document your decisions, and then review. So I'm going to stop there. I see David has joined us, Jasmine, and I think that's my last slide. I'm sure it is. Yep, there it is. So I'm going to get out of. Did you stop sharing my screen? Because I will. I do. No, this is new technology for me, folks.
No problem. Thank you so much, Aoife. That was so well done. And I have to say, this is actually the highest amount of participants we've had in a lecture, and I think that speaks to how important this topic is. So thank you for doing such a good job of speaking to it in a way that's comforting and clear. And so right now we're going to go ahead and move on to David's part. It looks like you're all queued up, so thank you.
Can you hear me?
Thank you.
Hi, we're going to have the questions and answers at the end. And right now we're going to have our second speaker, David, start speaking.
Thank you, Jasmine. I didn't have an opportunity to start with you guys. I'm sorry, but I had another lecture that I was participating in. And so that ended, and I was able to finally come in sort of like in the middle of it, but this is a great opportunity for me to discuss advanced directives under Illinois law, and so I'll be providing a legal perspective regarding what these things are and give you a general overview. There are lots of different nuances and details related to the legal requirements of advanced directives, and I'm sure that Aoife has done an excellent job in going through some of those things. But I definitely wanted to provide you with some legal perspective on this. If you are thinking of completing an advanced directive document, I would advise that you consult with either your attorney, the attorney that you might know in your family, or speak with at least our chaplains or social workers or providers to make sure that you are able to properly complete all the necessary parts that go along with the advanced directives. If these forms, and there are lots of forms here, that is part of that make up advanced directives. If you do not complete all the parts properly, then it just cannot be used as a legal authority in terms of getting the necessary consents or proceeding or not proceeding on a particular treatment. So it's quite important that all the parts of each section of the advanced directive form is completed properly with the assistance of others. You can, of course, complete some part of it on your own, but it's important to then seek others who are who know about the subject matter, so that they can assist you make all the necessary decisions and execute it properly. So the laws on advanced directives can be found both in state and federal statutes. There are, if you were to go look toward, Google has everything, right? So if you go to Google and you try to look up advanced directives and within the federal statutes, you're going to find that the statutes are interdispersed here and there and everywhere, and they're not going to provide a nice, cohesive sort of block of information for you then to proceed to completing this document. But the additional aspect of the federal statutes is that it's always going to reference the state statutes that govern advanced directives within that state. My title for the presentation is Advanced Directives under Illinois law for that reason, because it's the Illinois law on advanced directives that will govern everything you do in terms of advanced directives, right? So that's the bottom line. When you're executing an advance directive here in Illinois, it's going to be governed by Illinois law. So you're not really looking at federal statutes. But most states, including Illinois, will have legal provisions that will allow for other states' advance directives to be acceptable. So meaning, let's say you complete an advance directive in Wisconsin, that form is going to be acceptable here in Illinois. What the Illinois law is going to require is that whatever state the form is completed, that state has all the necessary ingredients to the ingredients that are required here in Illinois. So as long as we have that kind of mirroring of the required parts of the advance directives, then it's acceptable here in the state of Illinois. Should there be a situation where there are certain sections missing, where the Illinois state law requires it, then obviously that advance directive will not be acceptable. Any questions on that? All right.
There is a bit of a lag when it's done online, but people are typing in their questions that I'll share at the end.
Okay, great, fantastic. So what is the legal basis for an advance directive? Well, advance directives are, you can imagine them to be legal powers, right? And these legal powers are not really isolated powers, meaning they don't sort of live on their own by itself. The statutory powers are going to arise out of this fundamental principle of informed consent. And the fundamental principle of informed consent is that the patient has a right to give permission to healthcare providers for treatments, procedures, end of life decisions, withdrawing or withholding life-sustaining treatments, DNRs, et cetera, and so forth. There's a lot of them, right? But advanced directives are based on this fundamental principle that is embedded within our federal and state laws that says that patient has the right to give permission to our healthcare providers in terms of how they want to direct or self-determine the way that they will receive medical care and direct their lives and their bodies, right? So that is going to be the basis from which advanced directives derive its legal power. So then we need to have some legal understanding of what constitutes an informed consent. At least legally speaking, in order to have informed consent, the patient must be decisional. So this is an informed consent from getting it from a patient, right? So if we're getting it from a patient, the patient has to be decisional. The patient has to be given reasonable amount of information necessary to make a choice regarding healthcare. And the patient must voluntarily then make that choice without being coerced to make that choice, meaning there's an absence of coercion when we have proper informed consent. It is only when the patient is not decisional that then we got to look elsewhere to obtain informed consent, and that's where advanced directives come into play. When the patient is not decisional, and we need the consent to be able to either withhold or continue to provide certain type of medical care. Advanced directives become legally important because it is a legal tool that you have. And the patient or you are unable to make a voluntary choice, or when you're determined to be not decisional, you want to make sure that your wishes are then honored by our healthcare providers, honored by whoever's named, say, as your legal representative in one of the advance directives, right? You want them to honor your wishes. So advance directive, you can see it as a legal tool to make sure that as you anticipate, you might run into some healthcare issues where you become non-decisional or you can't make voluntary choices. You want to make sure that you have provided all the necessary ingredients for others to make the decisions as you want them to make those decisions. All right, so legal representatives being named through an AD will play a crucial role in that. The advance directive documents can stand in the patient's place and direct medical care on behalf of the patient. The reason why I mention that is because you can either have a legal representative or an alternate decision maker named through some of these advance directives to make decisions for you. Or you can have a document. You can have a document such as the living will or post, and to some extent, power of attorney for healthcare. You can have a document to authorize or direct medical care on behalf of the patient, right? So in terms of who the alternate decision makers may be here in the state of Illinois, they may be surrogates, guardians, agents under the power of attorney for healthcare, as they're required to be named within the document. Attorneys, in fact, under the Declaration for Mental Health Treatment Preference, we just call it the declaration in most instances, but that's for psychiatric care when the patient is deemed to be not decisional. That will be an advance directive that comes into play for those types of patients. Now, advance directives may be just documents, like I said before, but the living will post stands for, I don't know if IFA has gone through this, but it's a physician order for life-sustaining treatment. There's a form that Illinois Department of Public Health has created that is pretty much the standard at this point. There may be some variations, but that is pretty much the standard that all hospitals utilize for purposes of making sure that if the patient should choose, for example, a DNR, they can indicate it so in the post form. And the physician then would enter a DNR order reflecting the wishes as expressed through the post form, right? So post becomes valuable in that way. The power of attorney for healthcare, although an agent under the power of attorney for healthcare may be named, it can also limit the authority of the agent, right? So you can tell the agent, well, you may do X, but you may not do Y. Right, so the document will speak as your voice to direct the agent to consent or to refuse to consent to certain types of procedures and treatments. And the declaration as well. The declaration, although affords the patient or someone to have an opportunity to name an attorney, in fact, it's not necessary to do so, and you can let the declaration itself speak on behalf of a psych patient, so that all the necessary admission and treatment options are determined by the patient when the patient becomes not decisional. There are some other advanced directives considerations that you need to make. When we're formulating our wishes in the power of attorney for healthcare form or other forms, advanced directive forms, the patient can always, the living will, the patient can always limit the authority and limit permission through those documents. They will play a crucial role when the patients run into a similar set of circumstances and the patient is not there to consent or refuse, right? And so it'll provide the direction for the named authorities, such as the agent under the power of attorney for healthcare, to make those necessary decisions that honors your wishes, right? the beautiful thing about the document is that and other advanced directives, the legal representatives are really authorized to make decisions in only two ways, and I think the providers really need to be careful here, because things might not turn out the way the patient always wanted under those circumstances. But under Illinois law, the legal representatives can only make decisions in two ways, and it is prioritized, meaning they have to go through step number one, before they can then make an analysis under step number two. An analysis meaning analysis before they make a decision, right? And so the first way that legal representatives, such as the agent under the power of attorney for healthcare, the first method in coming to a decision is to make sure that they consent or refuse treatment based on what the patient would have wanted under those circumstances. It requires the legal representative, and to some extent the providers, to do due diligence and make sure that we know what these things are, right? And sometimes that can be expressed in the document itself, let's say the power of attorney for healthcare form, but it can also be revealed through the living will, pulse form. Whoever the legal representative is, including the surrogates, they must go through this process of trying to determine what the patient would have wanted under those circumstances. But the reality being what it is, we don't necessarily have that type of information. So in many instances, we're not going to know what the patient would have wanted. It's not really specifically spelled out. Although it can be spelled out, it may not deal with the specificities of medical care and the specific consents that might be needed for a patient who has a very particular type of medical condition. Of course, that's when legal representatives really play an invaluable role, because they stand in your place. But because the documents may not necessarily spell out these things, and the legal representatives may not know exactly what you would have wanted under those circumstances, the statute allows for then to go through what's called a best interest assessment or analysis, right? And that's step number two. That's when consent or refusal to consent to treatment is based on what will be in the best interest of the patient. This sort of presumes that the legal representative does not know what the patient would have wanted under those circumstances. And it also requires, and this is by operation of the law, right? The law will require the legal representative to go through this process to make decisions based on the legal representative's consultation after they have consulted with others, particularly the providers involved in the patient's care, and if significant, other family members' input, right? It allows for that kind of breadth in terms of assessing all that information to come to a decision based on what will be in the best interest of the patient. We cannot jump to step number two without having gone through step number one here in the state of Illinois. So, it's a good thing to have an advanced directives in light of this, and to make sure that you express your wishes to the best of your ability, so that it'll give clear guidance to whoever it is, the agent. It'll give best guidance to our providers when they have the living will and they need to utilize a surrogate for alternate decision making. When you specify it clearly, it'll give sound direction in terms of what they need to do. But if we didn't have that, there's also a way that statutorily speaking, at least, a way that a legal representative can make decisions, and that would be under a best interest analysis. So what will be in the best interest of the patient? It may not necessarily be what you would have wanted under those circumstances unless it's clearly expressed. So let's talk about the legal representatives. The most common ones are the surrogates and the agents named in the power of attorney for healthcare. Now, of course, there are other legal representatives here that I'm not mentioning, and I don't think it's necessary for the purposes of discussing advanced directives. Like, for example, the guardian under the Probate Act. There are so many different types of guardianships, including plenary guardianships, guardianship of the person, guardianship of the estate, limited guardianships, standby guardianships. There's a whole laundry list of these things, and they are officially legal representatives appointed by the court when the patient has been determined to be incompetent, right? So they will come into play when those things are at play. But I think for the purposes of this discussion, we need to hone in on advanced directives and how legal representatives, the common ones, interplay with advanced directives. Right. So the most common ones that interact with advanced directives are surrogates and usually those agents named in the power of attorney for healthcare. Like I stated before, the surrogate's authority flows from the statute, the Illinois Healthcare Surrogate Act. They're appointed by the attending when there is no power of attorney for healthcare, meaning if there is a power of attorney for healthcare, they will always supersede the authority of the surrogates. A surrogate cannot make end-of-life decisions, for example, to withdraw or withhold life-sustaining treatments, if the patient does not have a qualifying condition. And so where, let's say there's a scenario where a patient comes in, there is no power of attorney for healthcare, our social workers, our providers will look for a surrogate to provide the providers with the necessary consents, including refusal to treat. If it is the case that the patient is have a potential for there's a potential for withdrawal or withholding of life-sustaining treatment, the provider will engage in that discussion with the surrogate so that a DNR order may be entered, right? But a surrogate's authority only really begins in terms of that discussion if the patient has a qualifying condition. A qualifying condition is statutorily defined as a terminable condition, permanent unconsciousness, irreversible conditions where death is going to be the ultimate result. But it is a qualifying condition that has to be corroborated by two physicians. So there's a whole process of getting to that point where a surrogate is then going to make that decision to withhold or withdraw life-sustaining treatments, and then seek an order such as a DNR order. Right. So there's a whole process behind that. The surrogate's authority can also end in terms of their authority to make decisions regarding life-sustaining treatments should the patient oppose that surrogate or that decision. It doesn't matter whether the patient is decisional or not. If the patient does not want that surrogate to withhold or withdraw life-sustaining treatment, then that surrogate will not have the authority to consent for DNRs or DNIs. The surrogate's authority is defined by this priority list in the next slide, and it's statutorily defined. So what that means is that when the physician is looking to a healthcare surrogate decision maker, they have to go from number 1 all the way down to number 9. They can't start from the bottom and try to pick out anybody along the list. It's always going to be a priority process, right? They're going to try to, so providers or social workers, they need to look for a legal guardian if pre-existent, or a family can initiate that process with a probate court and attain guardianship over an individual. In that sense, they would no longer be a surrogate. If they are pre-existing, of course, they're surrogate healthcare decision makers, but they're also guardians as well. And that guardian will have tremendous amount of authority to make decisions, medical care decisions on behalf of the patient, but they may also be limited. So it's the providers are required to go through a process to make sure that the guardian has all the necessary and proper authority from the probate court to obtain consent. All right. So in most instances, we're not going to have a legal guardian. We're going to have a spouse or a partner in civil union who's then going to be authorized to make medical care decisions on behalf of a patient. Illinois does not accept common law marriage, so they may have a relationship that started in another state, let's say, that accepts common law marriage, and they've considered themselves to be married within that state. Once they move to Illinois or they're getting care in Illinois, Illinois statutes do not accept common law marriage. So unfortunately, we're unable to get consent from that individual unless they qualify as a close friend, which is number 7. Okay, so if we are able to or not able to find a spouse, then the next category of individuals that we'd be looking for will be an adult child, adult son or daughter. Now, in a very complex family dynamic, it might be the situation that the adult son is really a stepson, where there was no legal adoption that has been completed. That individual will not be able to consent on behalf of the patient. It's a majority rule if the class has multiple members within it. So let's say there are three children. The majority of those individuals will have to come to some kind of a consensus in terms of consenting or refusing to consent to a treatment, and we need to honor that. The parent also, in terms of somebody being a step parent, unless there was a legal adoption that was completed, we cannot get consent from that particular parent, so on and so forth until we get to a close friend category. It's a catch-all category in the state of Illinois, meaning that includes somebody like a cousin or a niece, nephew, a neighbor even. But the state of Illinois requires an affidavit to be completed and submitted to the hospital for documentation, so that at least from a healthcare perspective, we're doing due diligence in terms of making sure that this person is properly authorized to consent or refuse consent on behalf of a patient. So let's talk about somebody who is now going to supersede the authority of a surrogate, and this is where the advanced directives will play a key role. Power of attorney for healthcare being one of them. Remember that if you do execute the power of attorney for healthcare, they will supersede the authority of a surrogate, and so the providers will not be looking for any surrogate decision makers. Once an agent under the power of attorney for is located by a provider, then the provider will always go to that individual, even seek the documents of the power of attorney for healthcare, so that we can always work together to make sure that number one, we're doing what the patient would have wanted under those circumstances, and number two, if we don't have that information sufficient to consent or refuse consent for a particular treatment, then they will go through the best interest assessment together, so that they can consent or refuse consent for a particular treatment. And the power of the power of attorney for healthcare comes in when the principal or the patient can assign some or all powers to that agent. Right, and so the agent will have tremendous amount of authority, or limited in terms of what they're authorized to do. But it is that aspect of this advanced directives that give it its power, and really it'll direct the agents and the providers to do certain things for you, or not do certain things for you, depending on your wishes. Power of attorney for healthcare typically takes effect upon a determination that the patient lacks decisional capacity. So what that means is that, let's say you complete the document and the provider has it, the agent is fully engaged in terms of decision making. It will only take effect to that degree when the patient, typically when the patient has been determined by the clinician. Usually it's the attending physician, but it could be a qualifying physician as well. But if they're able to make a determination that the patient lacks decisional capacity, then it gets triggered. The authority of the agent gets triggered, and they're able to then provide all the necessary consents. But there is an exception under the provision now currently in effect. Laws have progressed a lot, and they were able to anticipate a lot of different situations for the patient, including a situation where the patient has decisional capacity, but they still want the agent under the power of attorney for healthcare to make healthcare decisions on behalf of that patient. So now the statute allows for this. It doesn't just take effect upon a determination of a patient's non-decisional capacity. It can also take effect upon the execution of the document, so that whenever the patient is in the hospital, the provider then needs to go through a process of determining whether or not the patient wants to make decisions regarding a particular treatment or procedure. And if they do not want to make those decisions, they can certainly assign that decision-making authority to the agent that is named in the power of attorney for healthcare. So that is now an option for us in terms of the properly executing the power of attorney for healthcare. I don't know how much time we have. We have until 2:15 or 2:20, Jasmine?
So you have until 2:20, and then we'll do questions at 2:20 to 2:30.
Okay, all right. The power of attorney for healthcare agents, they can also make mental health care decisions. And so it's not just medical care, but also mental health. There are surrogates, for example, or guardians are severely limited in terms of their ability to consent for involuntary admission or treatment. So usually it's either going to be the power of attorney for healthcare who will be authorized to make mental health care decisions, or it'll be the attorney in fact named under the Declaration for Mental Health Treatment to make those decisions on behalf of a patient who is not decisional. There are many forms out there. I'm sure that you've done some research online, and there are some online websites that has all these variations of the power of attorney for healthcare forms. But I really think that the best version of it is the state form, and the state form is based on the statutory short form. If you go to the power of attorney for actually it's called the Power of Attorney Act, and then within the Act, there are two sections: power of attorney for property and power of attorney for healthcare, which is at the bottom end, right? But if you go to that, there's actually a version of the short form, which is then beautified by the state that exists independently online, and you can definitely download the PDF version of it. Rush definitely has a power of attorney for healthcare form that reflects the state form as well. So I think the best version of it, because it contains all the legal requirements under the Illinois law, it is really the best version available. And so I would highly recommend using that. The critical thing here is, when you're looking at the form, is to review all the options listed. And Aoife has discussed this, and I'm glad I caught the tail end of it. But talk, meaning discuss, converse. Don't just do it by yourself. Make sure that others are aware of what your wishes are. Discuss various scenarios and choose the option that really best express what you will want under the circumstances, right? So that at the even if you have the document and it doesn't do these things, you don't want the providers and the agent named to start guessing as to what you would have wanted under those circumstances. So it's really good to talk about these things and come to an agreement if at all possible. But be comfortable at least with the decisions that you have made and express those clearly within the documents so that others, when they then are placed in a position to make those decisions for you, they know what to do, right? Um, um, I'm going to repeat this, but consult with your attorney or seek the assistance of a chaplain or a provider if you have any questions. Make sure to complete everything and not leave anything out. There are some stringent requirements when it comes to completing the witness section. For example, in the power of attorney for healthcare, the witness must be somebody who is witnessing your signing of the document, but also somebody who's totally not related to you in any fashion whatsoever. And that includes your providers, right? So if a healthcare provider is providing you with healthcare, they may not sign as a witness. So it's quite important that you find somebody who is completely detached. But this does include social workers, chaplains. They may sign as a witness, so be assured of that. It's just that if there is a conflict of interest, right? The interest being the interest of a provider versus your interest in wanting what you want, what you wish under a specific sort of circumstances. You want to make sure that you don't have anybody signing as a witness that contradicts what your wishes are. Here is a copy of the living will here in the state of Illinois. This is available to you online. Again, this is a state form. Again, there are lots of variations out there. If you go to an attorney and seek to complete a living will, they're going to have their own variations of this. But I think that the state form is really the best one. We have a living will at Rush that comports to all the necessary ingredients outlined here in the state form as well. But you can see the challenges, right? It's not simply just reading all the information contained in the living will. It comports with the legal requirements for the living will. But you can see, like, for example, down on the bottom of the first page on the left side, it has 2 witness sections. That means you need 2 witnesses to sign off on the living will. It will also include like certain information on who these witnesses may be. Remember, this is the living will form, but it also allows you to make an attachment to the living will so that if you can't express everything you want to within this living will, you can certainly attach your wishes, your desires under a specific set of circumstances to the living will, so that it's in addition to all the languages that are stated here, right? So that's really important in case you want to specify exactly how you want your living will to be expressed. Right? Now, I stated before that there's a way to, if there's certainly a way to create such powers through the advanced directives, the law will also provide a way to take it away from you, or you to take it away from others that you have authorized to make medical care decisions on your behalf. So for power of attorney for healthcare, you can do it. You can revoke the authority in writing, or you can verbally state so. You can certainly destroy the document itself. Be careful though when you're talking about destruction. If you don't tell others that you have destroyed such a document, and there are copies out there that providers have or your agent has, and the agent does not know that you've destroyed it, that might not be the best way for you to revoke it. So you need to make sure that you communicate your destroying of the document itself. Your decisional capacity is not relevant when canceling, so you may be not decisional and still revoke the power of attorney for healthcare, right? And you can only revoke it if you are the one who created the document, meaning you are the one who created the authority, the agency authority, right? And that means that you are the only ones who can revoke or destroy the power of attorney for healthcare. Some principals or some patients think that if you mar it, then that's enough to revoke, but it isn't. At the same time, it is sufficient as a revocation if intent to revoke is shown. What I mean by that is, let's say you mar it in such a way that your intent to cancel it is expressed, meaning there's a line going across the document. I think that that's sufficient for revocation of the document, and it's no longer good. Of course, the living will, you can write it to void it. You can verbally state it. You can destroy it. Same issues apply to the destruction here. Only the person who is executing, meaning the person who is completing the living will, may revoke the living will. Capacity also here is not relevant, meaning you may be not decisional and still revoke the living will. Agent under the power of attorney can override the living will unless that is limited in scope, and that's why it's crucial that you express clearly in the living will or even in the power of attorney for healthcare document that you want the agent to honor your living will. Right? The surrogate may be revoked in terms of their authority when the surrogate becomes non-decisional or unwilling or unable after the provider has made a reasonable effort to communicate with the surrogate. Or the surrogacy ends when the patient regains decisional capacity. For the post, and this is the last thing, the post form can be revoked or canceled by the patient when the patient has created the document, or it can be destroyed by a legal representative if the legal representative is the one who has executed the document. But it doesn't work across, meaning let's say the patient created the post form, it doesn't get then destroyed by a legal representative later on, right? So it has to be clear that it's either the patient or the legal representative creating the document, and then that can be expressed in the post form itself. Right? So I think that's it in a nutshell for me. Hopefully that covered. There's a lot to this. I'm sorry I couldn't go into all the details, but I think that's sufficient for us at least.
Thank you. Thank you, both of you. We already have a couple questions coming in, and I think that just speaks to how great your presentations were and how widespread it was. So thank you. Before I read the two questions or the few questions that we have online, I want to open it up to people who have joined over the phone. So if you have a question, you can go ahead and unmute yourself now and ask your question. All right, so we'll give another opportunity for those over the phone to ask their question at the end. But to start us off, the first person wrote, I have had to fill forms for this out a couple of times for brain surgeries. What I want to know about this is, can they be kept for me when my last day comes? And that's referring to the advanced directives.
I'm not sure what the question is in terms of if you have filled out advanced directives before you've had surgery, and you've said some things in those advanced directives. I'm assuming you've expressed some of your wishes, and again, like David was saying, primarily you have said who the person is to speak on your behalf. If you're not able to speak for yourself, if something has happened and you lose decisional capacity or clearness of head or whatever it is. I'm not sure what you mean by keeping those forms. They are certainly in the RUSH system. Anytime we have any documents that are signed, any consents that are signed, any advanced directives, they are stored within your electronic medical record and will be there forever, I guess, until such time as and updated. So, you know, if we found over 5 or 6 years that there were 2 or 3 different versions of the same document, the one that is the most recent will be the one that I suspect we would honor. But they are there. And I'm not sure if the question is also wondering, or going back to the what David was just referring to at the end. You don't lose decisional capacity forever. You can regain it, and you can take back the reins into your own hands and make decisions about your own healthcare. Once you feel, and your doctors feel, that you really are up to it, that you're able to grasp the complexities of conditions, the consequences of decisions, and things like that. So, but I'm not fully clear on the question.
Yeah, yeah, absolutely right. And what's important here is that these documents will live independently from the provider side, meaning, let's say there's a power of attorney for healthcare. You know, the provider may have a copy of that or may not, but you know, a copy of the advance directive should be provided to the provider, and so that, you know, it's documented well, and the provider understands what the wishes are as expressed in the advance directive. And then they will provide any necessary, they will put in any necessary orders to reflect the patient's wishes. So what does that mean? Let's say there's a pulse form, the patient has completed it together, because a pulse form needs to be completed together with a clinician, right? There are certain clinicians that are able to complete the pulse form with the patient. But once that is completed, then it will be documented. The original copy will go together with the patient, so that, let's say the patient goes to another facility, they may not have a copy of the pulse form, but once you give it to them, that will be documented within their medical records, right? And then the providers over there in that facility will look to it as guidance for medical care decision making. So these advanced directives, forms, documents can be transferred over to multiple different facilities and healthcare facilities and providers. The only important issue here is when you make changes to your wishes or you revoke it, you need to make sure that you communicate that with all the providers that you have given your advanced directives to, so that they know what the changes are or whether you canceled it. There needs to be clear communication regarding those things. Otherwise, it's within their legal right to assume that the advanced directive is as expressed and documented in your patient's chart.
Thank you. Our next question says, I am a healthy 70-year-old. My doctor has a copy of my medical power of attorney on file. I have a will and advance directive shared and signed. How often should these directives be reviewed?
I think what you need, they should be reviewed whenever there is a significant change in one's life. For instance, one of the first obvious one is if you have done an advance directive and you had named somebody, be it your spouse, and you now want to change it from your spouse, you want to change it to an adult child, or you've got a different spouse and your old spouse's name is on the advance directive, then you want to make sure that your current spouse is the person, so that the person that is named on it is still accurate and able. That's the other thing. As I said in one of my examples, the default goes to commonly goes to a spouse, and you want to make sure then that your spouse is able to make decisions and is able in the sense of has their own, doesn't have their own health issues or concerns. But also, actually, one of the things we didn't do within all of this is because frequently I find people don't want to upset their spouse by going to the next generation, and one can name a substitute in case the first person isn't able. And that's can often be a way of extending your advance directive. So if in the event of something happened to you and your spouse is already going through healthcare issues and is now overwhelmed with sadness because you're now incapacitated in the ICU, and while your children are overwhelmed, at least your children, your spouse could defer to the substitute in some shape or form. But that there is authority given to the substitute, and that can happen within the advanced care, within the power of attorney for healthcare document too. There's a mechanism in there to do that. But the short answer would be, if something in life changes, review your documents and change them accordingly. And maybe every year, as I said, depending on if you're healthy at 70, that's great. So it's not, it's like you get to a certain point and they want you to do a mammogram every year, or they want you to do a colonoscopy every 10 years. If they find something, they want it every 5 years, so it just depends on your own circumstances and your life and that.
Yeah. And I think I think that's beautifully stated. I think what it alludes to is the fact that, we need to make sure that all the ingredients that are placed in the advance directive can be applicable at any point during the next medical care scenario. So what I'm trying to say is, and I'll give you an example. Let's say that you have named somebody as the agent under the power of attorney for healthcare, and it's been 10 years, right? And this document doesn't have an expiration date. So let's say you have this power of attorney for healthcare that you have executed 10 years ago and have not been in touch with the agent. By the time you get to the hospital and we're looking for that agent and we're not able to find that person, then we're going to look to the successor agent, if so named, but usually they're not named at all. So then the power of attorney for healthcare really doesn't come into play at all at that point. We'd be looking to a surrogate decision maker who may or may not be really aware of what your wishes are under those particular set of circumstances. So it's important to make sure that you're able to somehow update that information with your agent named in those advance directive documents.
Thank you. And then we're getting a few comments here just thanking you both for all the information you've shared and for answering the questions. And so we are a few minutes past 2:30, but just want to again give one last opportunity for anyone who's on the phone. If you have any questions, you can unmute yourself now and ask your question.
Hello?
Yes.
Hello.
I just joined. I forgot about it. When will you have another seminar on this subject?
Oh, I can give you a call back and answer that question.
Okay, thank you.
Yeah, thanks for your question. And anyone else, if you have any questions, you can unmute yourself now and ask your question.
Hello?
Yes.
Hello.
Hello? Yeah, hi. I was wondering, Peter, how are you? Hello?
Good, Peter. We can hear you.
No, okay. I didn't know. I was going to ask the very good presentation. I wish I was a lawyer. He's very complex and smart. I tell you that. Anyway, and both speakers are wonderful. I was going to ask about what if you have older. You're not sure if you're going to live. Let's say they put you on a ventilator. I mean, I don't believe in Dr. Kevorkian, but what if you're in horrible pain for weeks and weeks, and you just can the doctor make that decision to say I'm sorry, or the life is just not, or does it have to be a family member?
Well, again, yeah. Go ahead. You want to start?
You know what I mean. The right to die. I don't. Nobody wants to die, but
yeah.
If your life is so horrible that you can't.
the best way, Peter, I think your name is.
Yes, I'm from Ireland. No, I'm just
well,
kidding.
That's a wannabe.
We're all
I guess.
Irish.
Yeah, they're
We're
all
all
wannabes
Irish.
anyway.
Yeah.
The way I think I try to say it, and especially in general terms like this, Peter, is it's true. None of us really want to die. Periodically, we get old enough and we get tired enough, and as I say, we get to a point where we're very ready to pass on. We've done it all, we've seen it all, and I'm quite happy to go on, to move to
Right.
die and to go on to the next life.
Right.
And certainly in Illinois, but that's so. That being said, generally speaking, none of us wants to die. However,
Right.
We all will die, and we have some control, a little bit of control over the how we die, and I think that's really what you're alluding to.
Right.
How can our pain and symptoms be best managed? And that's certainly one of the values like that I speak of. If not suffering is something you don't want to go through, nor you don't want to be on ventilators and have a prolonged dying process, then that's something, that's a value that can be expressed, and you need to let your family know that. And therefore, when you get to the point, where you have a qualifying diagnosis, i.e., so one of the first things, let me say, for people who have Medicare covers the expenses of hospice, but you have to qualify for hospice. And just being 99 and a half and living fine and everything doesn't qualify you for hospice. You have to have a diagnosis from which it would not be a surprise that you would die. So, but if you have a qualifying condition, then you have that option to exercise that how. This is how I want to die. I want my last days, weeks, months to be. And so you can influence the how of the dying, but not the fact.
But the doctor has to keep you alive, right? Legally.
No, that's.
I thought my brother's a doctor, radiologist, and he said pump her stomach. My mother, he was against pumping the stomach and doing extraordinary, but then when it happened, she died the next day anyway.
So
actually, David, in fact, families, patients cannot make the doctor do something to you if the doctor feels they're going to do you more harm than good. And doctors cannot stop people from dying. They can try.
What if
they do?
What if the person says, "Please, I can't stand it anymore"? I mean,
well, they can't make you die either, though. They can't actively do something to cause you to die.
No, but you're dead. You're almost dead. You're lying there on a ventilator. It's almost worse than death. I mean, you know what I'm saying?
And the family with the doctor, everybody understanding that the person is in the dying process, a decision can be reached. But and actually, Peter, it's interesting. People don't realize that the PULSed or the DNR, the Do Not Resuscitate, is a doctor order. And the doctor has to order the team not to do something. That's the interesting piece that is different than most of the other consents that people will sign. They normally sign consent to do something. I consent that you do this to me. But if I'm telling you not to do something to me, then the doctor is ordering everybody, don't do this to this person, in terms of don't provide ventilation or don't provide chest compressions, don't give vasopressors to artificially keep the blood pressure up, all of those ingredients that goes into resuscitating or attempting to resuscitate somebody. So it is a doctor's order at the end of the day, and but it's a little complex kind of for this type of general conversation.
Thank you, Aoife. Yeah, go ahead.
Unlike the state of Oregon, for example, that has that allows for the physician to assist in suicide, we don't have that here in Illinois. And so what's going to apply, at least legally speaking, in terms of what the doctors are authorized to do, they have to do everything in their power under what is reasonable within the practice, right? So there's a standard that they utilize in terms of determining what they can do and what is appropriate for a patient in those types of situations. The doctor, if push comes to shove and they need to make a determination, they will make the necessary clinical assessment and see if any further ongoing treatment or procedure is inappropriate. There has been other terms that's been used, medically futile. There's medical futility, principles and standards that's been utilized. But ultimately, it's whether or not ongoing procedure is going to be medically inappropriate for that patient, where death is imminent and there's no way to get around that. So it is at that point that the physician may enter into some kind of, they will place some kind of an order withdrawing care at that point. But that is, there is no clear legal standard in terms of medically inappropriate treatments here in Illinois, at least. But there's a lot of literature on this in the medical field. And different hospitals will create policies to handle such questions in a slightly different fashion, depending on the mission of the hospital. But that's how they'll approach that situation.
I'm going to have to sign off, Jasmine, and everybody. Thank you very much. And David, it was nice being with you on this presentation. And I just said to Jasmine, if there is any questions that you might have or think of for me, and I'm sure this goes for David too, you can always contact Jasmine, and she will coordinate getting answers to you as best we can. But thank you all for participating and listening to this presentation. And I will say goodbye, and everybody stay well and stay safe.
Thank you. Thank you both, David and Aoife.
Thanks,
You're
Jasmine.
so informative. You're welcome to sign off. I know we ran a little late, so thank you both so much.
Thank you, guys.
For our participants who are still here, who are here online, thank you again for asking questions and staying involved with this lecture. Just like Aoife said, if you have any questions that we weren't able to answer, or maybe some more parts to your question, please feel free to contact me, and I can relay those questions over to our speakers and get back to you personally. So if you have a question, you can call me over the phone. The number is 312-942-6995. And you can also email your questions to me at Jasmine, JASMINE _Chandy, CHANDY @rush.edu. So thank you all so much once again. Again, if you have any questions, please do let me know. And we're going to thank our speakers once again, and thank you to our participants.